providing speedy justice. The judges in the state, they dispose of more than 34 lakhs cases yearly. But the misfortune is that almost similar amount of cases are being instituted yearly. And the people who happen to read the data, they find that, look here, 60 lakhs cases were pending in year 2017, 217. And the data shows that the same figure is existing in the next year. So the normal criticism which comes is what these judges are doing. If the figure in the last year and the figure in the present year the same, then what they have disposed during 1 year. Unfortunately, the judges don't have any forum. The judiciary does not publish its domestic magazines to highlight its achievement. The judges are not expected to mix up and interact with normal people, thanks to this District Legal Services Authority that for some different purpose we get assembled for 1 or 2 days in a month now, and there we can explain the situation. So I always feel that the delay is being overemphasized, targeting the judicial performance. And more often, this criticism comes from the side which hardly has any experience how the judicial decision making is done. Without realizing the issues, we have issues of, say, infrastructure, we have issues of, say, understaffing. Adequate amount of judges are not there to contribute in the judicial performance. And since long, the judicial institutions have been in the last agenda as the educational institutions. They have been also put as the last agenda, non-productive institutions, not going to render much benefit to the state economy. Rather, they force the state to invest finance for no substantial gain. And this has been the approach. So, why I say these things? Because you are all law students. You must have thought in terms of going to either judge's profession or some legal profession. And I always say that don't join any of these professions with some bitter ideas in your mind. Be positive. Try to explain and understand the situation. I am always reminded whenever this kind of words are spoken. During the period of 1970 to 1980, or maybe 1960 to 1980, there was a fashion growing in Indian society. That was the period when the socialistic and communistic ideas were just growing, and most of the people who were in some intellectual profession, they like to show themselves to be close to the socialistic and communistic ideas. So in the process, they targeted all the religious institutions in the country and tried to deny the sanctity of those institutions. He had several publications those times available on some, say, a small town or big town, just targeting the religious institutions. So during that period, what we did was that we denied the sanctity of God and religious institutions, which was a great source of inspiration for the growing youth. So the role model in terms of God and religious institution lost its color during that period. Then when it just lost, the people have a tendency, something there should be, about which they can talk. So the justice now, it is post-80 phenomena, that justice and judicial institutions are being regularly talked about. And mostly they are being talked about as it happened during 60 to 80, that the people having no idea about religious institution, they used to talk about religion and God in a very, very critical way. So the people not having any idea about how the law operates, how the legal institutions work, how the judicial performance is done, they started talking about the judicial performance and so many issues with regards to this judicial performance. The people who never have read any judgment of the courts, they become the best critic of those judgments. So this period is continuing, it's still continuing. So as a law students, you must try to understand what kind of system you are going to have so far as the judiciary is concerned, what kind of problem the judicial institutions are facing, what kind of expectation the people are having from these judicial institutions, and then you have to pave your way. You need to contribute to something positive to these institutions. So that is one area I was really, I'm forced to speak about it many times, because when we talk about judicial performance, the delay automatically comes. Now the second aspect of this constitution making, the topic shows that how Dr. Ambedkar visualized modern India and what he tried to have in the constitution itself for the making of modern India. You can just imagine. This equality, it was not in existence so far as the society is concerned. We have a multi-layered society, and then conflict-ridden society. So the equality, man and women, they are equal. It is not known to the Indian society prior to the enforcement of the Constitution. So for the first time, the Constitution spoke in volume about it. if we, as pointed out by learned Kulshesji, he went through the preamble of the Constitution. It is so important. Justice, equality and freedom. Every kind of opportunity available to everybody on equal terms. A sense of fraternity to be developed in the society. And it speaks about it. One great professor, Professor P.K. Upendra Bakshi used to say that the preamble is the real constitution and the remaining is the footnote. So one who is able to understand the message of the preamble of our constitution, he will probably understand what our constitution expects and sees. So when the constitution was likely to be framed, what happened was that in about 1945, it was enough clear that India is going to achieve freedom. The Britishers are going back to their territory and India will get independence very soon. So Mahatma Gandhi wrote 2 letters in which he laid the scheme for the framing of the Constitution. One probably in 1945, the other maybe in 1948. And he wrote that we have to make the whole administration village-centric. He proposed that there should be Gram Panchayat and 50 Gram Panchayat should elect their leaders, and this number will further increase and it will ultimately reach to the highest post in the country. And in a very classical quote he said that India will achieve true freedom only when we will decide to live in villages, not in town, when we will decide to live in hut, not in palaces. So he was trying to decentralize, and the village was to become the lowest unit for the administration in the country. Now, unfortunately, his scheme and his idea was turned down by the then leadership for so many reasons. We cannot say, but the reasons were very obvious because at that time, just prior to independence and after independence, there was some real threat to the security of the country. Some external threat, some internal threat, the communal rights, and then of course every state is expected to be a strong state in terms of its military power, so that to keep the country integrated. So they adopted a different way, and they went for a federal constitution in the country. Federal constitution, you must be knowing as a student of law, the classical definition of Professor Riere when he said that in a federal constitution, the power between the center and the state is divided in such a way that each become free in their own spheres. Because it was thought by the Constituent Assembly that complete autonomy to the state may not be very helpful in keeping the India united. We were having more than 500 states and kings during that period, and it was very difficult to fill them or to force them to join the Indian Federation after independence. So we adopted a formula that we will have a federal constitution, but we will have a very, very unitary and centralized tendency where the center will be more and more powerful. It was really demand of the country and then the existing situation at that particular time. Then we have protection of human rights. We have so many provisions, the emergency powers, the amending powers, everything was written in the Constitution. Almost 400 articles. Contrast to the Constitution of USA, which initially provided for only 7 articles. We had lengthy Constitution. We adopted all good things from existing Constitution in federal countries. So that was provided to the country, and I read somewhere a time back that for the good work, that is the drafting of the Constitution, Dr. Bhimrao Ambedkar was given honorarium PhD for it. So the Constitution, we all know that it is a kind of social document. We visualized for a social document. It more speaks about socio-economic development of the country. It tried to attempt on national regeneration and renaissance. So the most important, which was characterized to be the most important chapter of the Constitution, was the chapter relating to the fundamental rights. We all know that when this chapter was being framed, a number of rights were provided. Not the 7 fundamental rights, more than that, enough rights. And during the course of discussion, it was felt that there are certain rights which cannot be immediately enforced, and the state may not be able to provide those rights. So they made it positive rights and negative rights. The negative rights were kept in Part 3 as fundamental right, and the positive rights were kept in Part 4 as directive principles, obligating the state to achieve the targets which have been provided under the Part 4 of the Constitution. So, what was the constitutional heritage? To speak precisely, the one was good governance, the other was the protection of the rights of the people, the third was the socio-economic development of the country, and the fourth was justice to all. And with these kind of constitutional heritage, the country had to proceed. So all the institutions like District Legal Services Authority and even judicial system, it comes for 2 purposes, that is justice and then the protection of the fundamental rights, which also include the human rights of individual. So a great constitution was really created. But we all know that the constitution cannot work itself. The result of the constitution highly depends on the persons who are expected to act according to constitution. The functionary, the machinery, the agencies, the instruments which are visualized to enforce the constitutional provisions, they are to work, and to what extent they render and work, that really ensures how much the objective of the Constitution is going to be achieved. So there may be, for so many reasons, there may be some lapse and failure, and all the targets and objectives might not have been achieved. But at least 1 or 2 aspects which needs to be underlined is that despite all the conflicts in this kind of multi-layered society, divided on the basis of culture, language, caste, religion, etc., we have been able to keep united from the last 70 years, and there is no possibility at all that the unity is going to be breached by anyone. And that is a great satisfaction as a student of Constitution for everyone. The justice system, I again say that we all know that initially the litigation was not this much. The right awareness was not to that extent. But with the awareness of the rights in the society, the litigation is coming in bulk. And looking to the state capability, financial capability, it is sooner not possible to add more staff and more numbers to the district level. The district judiciary particularly has to render goods with the existing number and staff. And everybody is motivated in a way to dispose of maximum number of cases. And as a district judge, I always say that the judicial officers at the district level, in all part of the state, I say, because I had the interaction with the judges of the whole state at least thrice when I was in the Judicial Academy in UP. So all working very hard. Maybe some mischief may be there, but it is really satisfying that all working very hard and they are trying to render much more, sometimes beyond their capacity and capability. Now the third aspect is this access to justice area. I am not going to take or enter into detail, but what is relevant for your purpose is that the District Legal Services Authority is trying to involve all the law schools in the campaign of legal aid. We all know that many more people, and it is with the poor people and deprived sections of the society, that one or other day their rights or status is going to be violated by someone. They are not knowing the law, they are not knowing the procedure, they have no idea about how to go in the courts and put their cases. They don't have financial capacity to pay to the lawyer, and that is where this legal aid campaign is very relevant. We all know that the District Legal Services Authority is providing free counsel to any person who is not capable of getting a counsel for his case. The deprived persons who are in custody, deprivation due to poverty, because of the labor structure in the country and society, they have been also made eligible to get free counsel and free aid by the District Legal Services Authority. What you have to do is to convey and popularize this institution so that maximum people may know about it, and whenever they get the opportunity or they want to, they may come to you or to the District Legal Services Authority for getting what has been provided under the Legal Services Authority Act. So there you have to do something. The next thing which I always emphasize is that throughout the legal aid campaign, you have to make it very clear to the persons with whom you come across that the real path is to have amicable settlement of the dispute. It is only when the amicable settlement is not possible that people should travel to the court system. It is like that if you are suffering, say, some mild fever, you are not expected to go to some medical institute. You have to go to some clinic, to a doctor. And sometimes even the medical stores may be providing a small paracetamol for that mild fever, and that will work. So you just tell those persons, the prospective litigants, that when you fail to enter into your own settlement, then only you should travel to the court system, because the court protocol is different. It has to observe the protocol given under the Civil Procedure Code and Criminal Procedure Code. And the protocol may be sometimes very lengthy. The procedural law has never been meant to cut down the procedure. It has been meant to provide a fair hearing to both the parties. So we all know that 1200 provisions are there with allied rules like general rules and all. The Civil Procedure Code has been given in your hand, which is used for the disposal of one civil case. And everybody who is capable of financially, he can take all advantage of those procedures. And most of the time, when the people are in litigation, the person who is feeling that he can lose, he attempts everything to delay the disposal of that case. Now the courts have to work within that parameter of procedure, observing all the procedural protocol. The courts are never expected to jump over it. It is not possible if the alphabetical protocol provides that after A, B will come. The procedural protocol provides that this procedure and thereafter another procedure. So it gives all opportunity to a litigant, if he is capable of litigating, to continue in litigation for a very, very long time. So the message should be conveyed that the people should try to resolve their conflict sitting together rather than by just bringing a litigation in the courts. And then, of course, to our learned Kulshesam, we all know that all now the law schools, they are including this free legal aid and mediation and alternative dispute redressal as a course for the law curriculum. But I can remind you about the situation that what happened was with the legal system, that the society never assessed the capability of a lawyer on the basis that in how many cases he has been able to bring amicable settlement between the parties. The professional skill of the lawyer, which is assessed by the society, is on the basis of the parameter how long he can continue in the litigation, even for a very, very rotten case. So that there should be some improvement in that area also. The students should be really taught in the fashion so that when they enter into the profession, they go first for the amicable settlement between the parties. And then if at all required that they should go for litigation, if the patient at all requires that there should be some surgical operation for his illness or ailment, then he should go to the surgeon, and not for a mild fever he should go to the surgeon. So this is the way you should carry on in your legal education, and you should try to understand the law in that fashion. I know and I can realize that it is almost a trespass on your academic session. When we come, we just trespass your academic session. But as a district judge and chairman of District Legal Services Authority, we have our own limitations. We have to sit in the courts during the court hours and try to dispose of the cases which are coming to us. So even though I always feel and I find myself very, very interested in interacting with the students of any law school, But with that limitation that we have to go and sit in the courts. And you know that the judicial institution, they are expected for their punctuality. You will always find that the judges, they are just sitting in the court and doing some work in the court. So ultimately we have to rush to the courts when this program is over. So just I seek apology from all of you that I have trespassed, and many of the students may be late risers. I have my own children, they are very late risers, and forcing them to come to their institution on say 9 o'clock in the morning, it is just forcing them for what they are not really prepared nowadays. So therefore that I seek apology from all of you, and I just thank Honorable the Chancellor of this university, the Dean Law School here, for organizing and giving us the opportunity to interact with such brightsome student of law. So long as these kind of institutions, but then one thing I always say to Kushe sir, that I don't think that academic institutions should run in such a comfortable situation, because the students should be prepared for the odd situations they are likely to face. If you go to the district courts, you will not find that the courts are air conditions, and you will not find this kind of amenities in the court system. Nowadays, and in Noida, you can get some good courtroom and all that, but in most of the courts in the state, you will not find electricity supply, and in a very this summer season, the presiding officer always you can find sitting without electricity in the court and doing the judicial work. So, and the whole society is running in this kind of odd situation. You are part of that society. So you must be prepared for those odd situations you are likely to face when you are not going to stay lifelong in this institute, remember. So you are likely to just face those kind of odd situations when you are face to face the realities of the society. So be prepared for that. Don't feel that it is your permanent abode, I would say. So thank you very much, sir, for giving me this opportunity. Thank you, everybody.